An Ohio judge yesterday acquitting a Cleveland police officer in the shooting deaths of two unarmed black suspects. Officer Michael Brillo was one of 13 officers involved in the 2012 shooting and the only one to face criminal charges. But the judge finding him not guilty of voluntary manslaughter, saying that the state failed to prove that he fired the fatal shots. The Department of Justice, headed by Attorney General Loretta Lynch, is now reviewing the case. Let's bring in David Schwartz and Keisha Heaven. They are both very fine defense attorneys and former prosecutors. Good to see you both.
Hello.
Good to see you too.
Before we get to causation, because that was really the judge's decision, he also decided that this was self-defense. Keisha, a total of 137 shots are fired by police at the car. All the cops except Brillo stop shooting. Brillo jumps on the hood of the car and fires 15 rounds. Does that sound like self-defense?
Not at all. And I think if he really thought that these individuals were shooting at him, he would not stand on the hood of a car and continue to shoot. He would have been concerned about his own safety. And this definitely was excessive force, in my opinion, and excessive use of shooting. Like, it was ridiculous, so I can't see that being self-defense at all.
You know, David, the judge said Brillo reasonably perceived a threat, and jumping on the hood of the car and firing his weapon, said the judge, was protected by law. Really?
Well, we have to look at the surrounding circumstances here, and I'm going to say something that's going to shock people right now. What I'm going to say is, when you're traveling at a high rate of speed through the great city of Cleveland for 22 minutes, eluding with 60 police cars following you and putting yourself at risk and putting other lives at risk, there's a great chance that you're going to die in that act.
But
wait a minute, wait.
There's a great chance that someone else is going to die.
Rodney King led police on a high speed and a slow speed chase. It was a bit mixed, and then he was beaten by police.
Right.
Are you suggesting King deserved to be beaten because he led them on a chase?
I'm talking about the surrounding circumstances here. And it's not just as simple as somebody jumping onto a car. Now, when you're in that type of intense situation and you start firing, look, you know, it's a very intense situation. Could it have been criminally negligent homicide? It could have been.
But there's no reason to shoot that many rounds. And the fact that they were on a high-speed chase and they said they shot at these individuals because they thought they used a weapon towards them, there was no proof of that. There was nothing that was hit. No one was shot. That's not enough to use that type
Well,
of...
self-defense, which the judge agreed with, seems a little fishy, but that's not why he decided to acquit.
Right.
He focused on the cause of death. Take a listen to the judge.
The state did not prove beyond a reasonable doubt that the defendant, Michael Brillo, knowingly caused the deaths of Timothy Russell and Melissa Williams because the essential element of causation was not proved for both counts. I therefore find the defendant not guilty of counts 1 and 2 as indicted.
Basically, David, the judge is saying the victims were shot so many times we can't tell who killed them. Therefore, I cannot legally find Brillo guilty of killing them.
Right, and not only that, in a criminal case, it's the DA that has to prove guilt beyond a reasonable doubt on each and every element of this case. So they have to prove beyond a reasonable doubt that those shots are the fatal shots. And the judge decided that they failed to do so.
But you know what? One thing in criminal cases is there's always a lack of direct evidence. This is circumstantial evidence, and I think that there was enough to say this police officer standing on the hood of the car.
There were 13 cops in all, and the judge said, I can't single out this one guy if you can't prove which bullets actually killed the two victims. Look, I want to ask you about something else. Prosecutors cannot appeal a not guilty verdict, double jeopardy, but the feds could try him under civil rights charges the very same way the feds tried the 4 police officers in the Rodney King case who were acquitted in state court, right?
Absolutely.
David?
Yeah, no, they absolutely can review the case, and they can bring civil rights charges if they deem
But don't they have
it's a tough burden.
Don't prosecutors have to prove, Keisha, that the motivation of that man, Brillo, was racially based?
They do, and one of the things that, in my opinion, will help the state to prove that is that there's some
You mean the
studies,
feds?
the feds, there are studies to show that there are some racial profiling and excessive force amongst African
It's got to be relevant to the defendant in a federal case.
It's going to be impossible to prove in this case.
Yeah, I don't
okay?
see how you can do it.
But you have to look at the history of this particular officer or the officers involved, and you have to look at how many people they pulled over. There's
Yeah.
statistics that they can look at on
Well,
those
look,
individuals.
two of the officers were convicted in the Rodney King case, so they might be able to.
Right.
And again, you know, just because the police officer fired his whole weapon doesn't mean it can't be self-defense.
All right.
It happens a lot.
ridiculous.
They also convicted in the Crown Heights case Lemrick Nelson on civil rights violations. So it does happen. Keisha Hebben, David Schwartz, good to see you both.
Thank
To
you.
see you too, Greg.
All right.